Welcome back, ladies and gentlemen, to an afternoon legal breaking reporting video analysis update. The Supreme Court is set to rule against conversion therapy in the Colorado case that was brought by a therapist. Let's view this reporting by The Hill. Again, this has an automated voice. In other words, an AI-generated voice reading it to us. So in a way, again, let's take a look and listen at today's reporting. The second reporting by The Hill, which means, ladies and gentlemen, that the Supreme Court does have concerns over free speech rights concerning conversion therapy. Ladies and gentlemen, without further ado, the article is titled, Supreme Court voices free speech concerns over conversion therapy bans. Ladies and gentlemen, without further ado, the article reads, the Supreme Court appeared open to a Christian counselor's free speech challenge to Colorado's conversion therapy ban for minors during oral arguments Tuesday. Tuesday being today, my editorial edition, ladies and gentlemen. Several members of the court's conservative minority expressed concerns about accepting the blue state's assertion that it is regulating, ladies and gentlemen, professional conduct, not speech. Quote, just because they're engaged in conduct doesn't mean their words aren't protected, unquote, Chief Justice John G. Roberts said. It looks like blatant viewpoint discrimination, unquote, Justice Samuel Alito quipped at one point. Not all the conservative justices were so vocal, including Justice Brett Kavanaugh, President Trump's second appointee to the court, who remained quiet Tuesday. The court's liberal wing, meanwhile, questioned whether the counselor had the right to bring the challenge. Okay, I'm liberal and all, and I see where they're coming from, but she has a point. But the counselor does have a point as well. all therapy should be accepted no matter what. Conversion therapy should be a right. Continuing with the reporting, ladies and gentlemen. The case is set to have national implications, with more than 20 states having enacted similar bans to the one in Colorado. A decision is expected by next summer. In 2019, Colorado prohibited licensed mental health counselors from engaging in any practice or treatment that attempts to or purported purports to change a minor's sexual orientation or gender identity. Violations can carry $5,000 fines, and counselors can be suspended and stripped of their license. Colorado contends it is a lawful regulation of healthcare treatment, pointing to major professional medical accusations that suggest conversion therapy ladies and gentlemen, is ineffective therapy and can be harmful to minors. Every theory that it's relied on has been debunked. Colorado Solicitor General Shannon Stevenson told the justices. Alito questioned that assertion, pointing to when many medical professionals once believed people with low intelligence shouldn't be permitted to procreate. The medical consensus is usually very reasonable and it's very important, but have there been times when the medical consensus has been politicized, has been taken over by any ideology? Alito pressed the state. It's a sentiment advanced by Kaylee Childs, the counselor who argues Colorado's law is trying to control her conversations with patients to suppress disfavored views on LGBTQ rights. This law prophetically bans voluntary conversations, counseling, wives held ladies and gentlemen, widely views on debated moral, religious, and scientific questions. James Campbell said, Charles' attorney. The Trump administration supports her lawsuit. Okay, really, ladies and gentlemen? Who cares if the Trump administration supports the lawsuit? Not me. I don't care what the administration of Donald Trump supports. Their opinion does not matter to me. There is no separate non-speech, ladies and gentlemen, conduct being regulated here and professional medical treatment not exempt from the ordinary First Amendment rule. Principal Deputy Solicitor General Hashim Moopan, Moopan, said, if the High Court agrees, it has long held such laws to be presumptively unconstitutional by holding them to a demanding test known as strict scrutiny. A district judge and a divided panel on the 10th U.S. Circuit Court of Appeals disagreed, upholding the law and spurring Childs to petition the High Court. Even the Supreme Court applies the stricter test. It remains to be seen whether the justices will outright strike down Colorado's law, however, or send the case back to the lower court to apply the more demanding standard. The court has a pathway to resolve the case without delving into those weighty issues. However, Justice Sonia Sotomayor, the court's most senior liberal jurist, in particular questioned whether Childs faced an imminent enough threat of enforcement to bring the case. Quote, this is an unusual case because we have basically 6 years of no enforcement of this law, 3 before this lawsuit, 3 cents, unquote, Sotomayor said. The Williams Institute, ladies and gentlemen, estimates that $698,000 US, 698,000 US adults have received conversion therapy, including 350,000 U.S. adults who did so as adolescents. Tuesday's arguments follow a series of challenges the Supreme Court has taken up concerning Colorado's broad LGBTQ protections. Continuing, ladies and gentlemen, in 2018, the court ruled 7-2 that Colorado violated Cake Baker Jackson, ladies and gentlemen, Jack Phillips's First Amendment rights by prohibiting him from refusing to bake for same-sex couples' weddings. They didn't violate his rights. He could have baked for the couples. He has that right to bake for anyone he has, including same-sex couples. Two years ago, the court ruled against Colorado, again when website designer Lori Smith appealed to the court a bid to refuse designing websites for same-sex weddings. Childs is represented by Alliance Defending Freedom, ADF, a conservative Christian legal powerhouse that represents ladies and gentlemen, represented both Phillips and Smith in the earlier cases. Childs' challenge to ladies and gentlemen, was supported by outside files by Christian counseling and medical groups. The U.S. Conference of Catholic Bishops, the Church of Jesus Christ of Latter-day Saints, Catholic University of America, and Beckett Fund for Religious Liberty, and 20 Republican state attorneys general. Meanwhile, Colorado's defense was supported by the Trevor Project, FLAG, the American Psychological Association, nearly 200 Democratic members of Congress, and 20 Democratic state attorneys general. It's the first of several cases implicating LGBTQ protections at the court this term. The justices are also set to rule on whether states can ban transgender girls from competing on girls' school sports teams. They shouldn't be allowed to ban girls from, transgender athletes. They shouldn't. It's completely ridiculous how they even brought this case. Last term, the court upheld Tennessee's ban on transgender health care for minors in a 6-3 decision along ideological lines. Though that case implicated different constitutional issues, Justice Ketanji Brown Jackson raised it at Tuesday's argument. Quote, "But the regulations work in basically the same way, and the question of scrutiny applies in both contexts," unquote. Jackson said, quote, "So it just seems to basically, ladies and gentlemen, seems odd to me that we might have a different result here."